3, 2, 1.
So today we are going to talk about termination of an employment contract. And to terminate an employment contract means to bring that particular contract to an end. So either parties, the employer or the employee, can decide to terminate that employment contract. And we have various reasons that can cause termination of the employment contract, or factors that can cause termination of an employment contract that you're going to look at. There are like 6 factors that can cause termination. So the first factor that can cause termination of an employment contract is termination by mutual agreement. And this one is based on the doctrine of freedom to contract, that either parties usually have that freedom to contract that is supposed to be not forced, is supposed to not be under duress or undue influence. So these parties are supposed to enter that contract freely, and they are free to terminate that contract that is not supposed to be influenced by government, or there's not supposed to be government intervention or redundancy. So the government is not supposed to intervene in this. This is just a matter between those parties that enter into that particular contract. So another reason for termination is by frustration, and this was held in the case of Elgemalji versus Elgemalji versus Cheongyi. And in this case of Elgemalji versus Cheongyi, they brought out those factors that can cause supervening events or supervening factors. So these are factors that are not laid out in the contract, and this is whereby a frustration is whereby a contract can be brought to an end by supervening change of events. So these events like death of the employer, bankruptcy, liquidation of the employer, and imprisonment of the employer. So under those circumstances, that contractual relationship can be terminated or be brought to an end. So we also have another ground for termination of the lapse of time, and this is whereby there's that particular time that has been set out in the contract. When that particular time elapses, then that contract shall be brought to an end. This is the specific terms. For example, the civil servants usually serve for 60 years. So after the end of 60 years, then that particular contract, employment contract, shall be terminated under the ground of lapse of time. We also have a termination by notice, and this is whereby the expiry of a particular notice that is set out in that particular contract. So there is usually that notice that is set out. When that notice gets expired, then that contract shall be brought to an end by either party. So if there's no that notice in that, then that notice can be set out by common law. So we also have another ground for termination that is by redundancy. And under redundancy, this is whereby that company that has offered employment comes to an end or ceases to exist. So under redundancy, contract can also be terminated, and it's set out in section, I think, 45 of the Employment Act. So we also have another ground for termination of dismissal, and dismissal is whereby dismissal can be done without giving notice, whereby the employer has acted within the lawful grounds, and whatever is doing is within the agreed terms of the contract. So under those circumstances, the employee can be dismissed if he has violated the requirements or the agreements of the contract. So there are all the grounds for dismissal, whereby the employee maybe is facing charges, is supposed to be imprisoned, where the employee is drunk, or the reasons for drunkenness is a criminal, is facing some criminal charges, or is just not supposed, is not fit to serve, or on either grounds that are set out that can cause his dismissal. So we also have the remedies that can be there when a contract has been terminated, and these are specific performance and damages and repudiation. So those are the reasons. So this contract of employment can be terminated under those circumstances. that I have